about hypnosis and court opinions and what they have in common. And what they have in common basically for court cases is that they use fictions and metaphors, rhetoric, and those kinds of things. And that's basically the same thing that is done in hypnosis. When a hypnotist puts a patient into a certain kind of state where he's more open to suggestion. So today we're going to talk about a comparison between the two, and I'm going to show you how they are much the same. So I'll start with some quotes from Legal Fictions by Lon Fuller. Bentham says, "A willful falsehood having its object the stealing of legislative power by and for hands which could not or durst not openly claim it, but for the delusion thus produced could not exercise it." So what is he saying? He's saying that if judges want to legislate from the bench, they have to use fictions to make it appear as though they're administering justice in the way they perceive the laws to be intended to be. So this way they can legislate from the bench while not being able to claim, or while being able to claim they're not legislating from the bench, because as we know, judges cannot legislate from the bench. So then Austin, who's also a jurist, Bentham and Austin are jurists. That means that they are lawyers, attorneys, legal scholars, judges, or legislators. So something to do with the legal system, our legal scholars. So then Austin says, "A wish to conciliate as far as possible the friends or lovers of the law, which they, the judges, really annulled. If a praetor or other subordinate judge had said openly and avowedly, 'I abrogate such a law,' or 'I make such a law,' he might have given offense to the lovers of things ancient by his direct and arrogant assumption of legislative power. By covering the innovation with a decent lie, he treated the abrogated law with all seemly respect, which he knocked it on the head." I think that means whilst. Whilst he knocked it on the head. Okay, so what he's saying here is that, in short, a judge, fully conscious that he's changing the law, chooses for reasons of policy to deceive others into believing that he's merely applying existing law. So we know that judges cannot legislate from the bench, so they cannot create law from the bench. So what they do is they take the legislation and they interpret it, and then they try to show proof of why their interpretation is correct. Okay, and I talk about this a little bit more. It cannot be positively affirmed that Bentham and Austin were wrong. It cannot be proved that courts may not, in some instances, have employed fictions with a deliberate intention. Sorry about my misspelling. Of deceiving the public. But most of us would feel that this interpretation is somewhat uncharitable to the courts. In the first place, it is a little difficult to see how the supposed deceit could actually succeed. Bentham and Austin were not fooled by it. It is likely that anyone who knew the facts, such as what the pre-existing law was and was the fiction accomplished, could be deluded. So I think I said it is, but I think it likely, so it's a question. So I spoke of this problem in a video, which was over an article called "Statutes with Multiple Personality Disorders." The article was about how legislators, such as the ones in Congress, write its laws to be vague, knowing that the departments and agencies will interpret the law as they see necessary. So they just interpret it in whatever way suits them. And they know that judges then side with the department or agency's interpretation rather than the legislator's intent of the law. So in the video, I further described this situation where I talked of vague words in legislation, such as the word sleep. So I made a video on this also, which is something brought up in Legal Fictions by Lon Fuller. So where the law states no one may sleep in a train station, however, when a homeless man brings his blankets into the train station, lays them on the floor, and lays on them, appearing with all intention to sleep in the station, has not yet closed his eyes, is not arrested or cited. However, a man who's a paying customer and has a 5-hour layover closes his eyes while sitting up in a chair waiting for the next train is issued a citation or arrested. Therefore, sleep is vague and it's interpreted by the police, and the intention or the interpretation is deemed the law rather than the legislative intent. Therefore, a law can mean anything to anyone, and judges side with whatever's interpreted, which allows them to interpret the law rather than understand it and administer the law. So the judges will just side in whatever the police decide. When the police make an arrest or issue a citation, the judges just side with them instead of looking at the intent of the law. And if you try to argue with a police officer over a ticket, he'll say, just tell it to the judge. He doesn't care. So continuing on with Bentham and Austin, the writer Fuller says, it is true that the fiction may obscure the process of legislating. So he's saying that when a judge is doing fiction in court, he's doing it in a way that obscures the fact that he's legislating from the bench. So he does it without deceiving anyone into the belief that no change has occurred in the law. I may serve to create the impression that the change is no greater than that involved in the ordinary case where legal principles are extended by way of analogy. It may temper the boldness of the change, but inasmuch as it does this, the fiction probably has as much effect on the judge employing it as on his audience. And this brings us to a consideration of emotional conservatism. And then he goes on to explain emotional conservatism, but I'm not going to get into that in this video. So hypnosis, what is hypnosis? Hypnosis and script writing. Quote, you will find suggestions that are highly indirect, permissive, and metaphoric, and ones that are also very direct, forceful, and authoritative. So this is a quote about hypnosis and how to perform hypnosis. So they're done by suggestions, and suggestions can be through metaphors, they can be direct, they can be indirect, they can be analogies, just like we saw up here. The analogies that judges may use analogies to compare two cases that may in some ways sound similar but really aren't, and that's one way that they bring forth the fiction to make it look like they're not legislating from the bench when they are. And these tactics that they use when writing fictions, when judges write fictions, these are the same tactics, if you want to call it that, a hypnotist will use when they write script. And the script is catered to the particular person, just like a court opinion is tailored to the particular case. So we cannot always know for sure which ideas will produce the desired motivation. As Erickson said, so this is about hypnosis, you provide a multiplicity of suggestions. The more suggestions that you give and the more simple you give them, the greater the possibility of getting some of them accepted. Your task isn't to force acceptance of suggestions. Your task is to present a sufficient number of suggestions so that he will willingly take this one and that one. Okay, so this is in hypnosis. You're just making suggestions, and then in hypnosis, it's more directed to an individual person. It's a one-on-one kind of situation, whereas a judge, when he's writing fiction, he's not necessarily writing it for the people in the court as much as he's writing it for the people who are going to read it outside the court, because they have to accept his opinion. The popular consent. Okay, so the people have to accept it. The populations have to accept it. And if they accept it, then no problem. Depending upon the individual, direct, indirect, metaphoric, and insight-oriented techniques may be employed to alter behavior, affect physiologic processes, imagery, perceptions, cognitions, and the internal dialogue of patients. An implied directive usually has 3 parts. Okay, a time-binding introduction. So I put this in here because when judges write cases, court opinions, when attorneys write their papers, when Congress writes legislation, and when presidents write executive orders or memorandums, they're all done in a certain way. And they're done in a way to where it sort of slowly brings the reader around to the point of accepting whatever it is they have to say. So this is the same way scripts are written. So a time-binding introduction, an implied suggestion for an internal response that will take place inside the patient, a behavioral response that will signal when the internal response or suggestion has been accomplished. James Bray belongs the credit of having first clearly perceived that the phenomena were due not to any mysterious or supernormal emanations, but to the power of suggestion alone. Acting on a subject whose suggestibility has been artificially increased. This view, which has been abundantly confirmed by Lebault and the Nancy School, is now universally accepted. The researchers of modern times are mainly attempts to systematize the phenomena, to explain how it is that suggestion arrives at such results, and to define the nature of the condition which is characterized by such a marked increase of suggestibility. The first of these claims has, to a great extent, already been successfully accomplished, but the others seem a long way from complete realization. So this is a quote from a very old book, because hypnosis has been around for a long time, just has the law, and just so has medicine. So hypnosis was used a lot in medicine, because back in the old days, medicine was in the same field as psychology. So it was a doctor who would do both. And because the brain and the body are connected, they would use the brain to help heal the body, and they would do it through suggestions. So to get people to behave and to do what the law wants them to do, they used suggestions in laws, such as you better behave or else, meaning, we have the power and you don't, and we'll put you in prison if you don't behave. So pay your taxes or else. In order to understand the gradual development of modern hypnotism from animal magnetism, we must distinguish 2 points. Okay, so there's only really a couple things in here I want to point out, but this is a long section. That there are human beings who can exercise a personal influence over others, either by direct contact or even from a distance. This is true. This is true when you are approached by a salesperson. This is true when you're spoken to by your doctor. This is true when you're brought into court. This is true when you're talked to through the radio or the TV by a politician or watching a television show. Some people are more influential than other people. Some people, they are more skeptical, and they don't believe things that they hear just because they heard it. Other people will believe everything they hear. One of my favorite lines in a show I watch is, "These people are children and children love stories." So people that are more uneducated are very easy to hypnotize. And I've been saying for a while now that the dumbest people in the world are gonna rule it, because for one, they outnumber us, and two, they believe everything they're told. So he goes on, and secondly, the fact that particular psychical states can be induced in human beings by certain physical processes. The second fact especially has long been known among the Oriental peoples and was utilized by them for religious purposes. Kieswetter attributes the early soothsaying by means of precious stones to hypnosis, which was induced by steadily gazing at the stones. This is also true of divination by looking into vessels and crystals, as the Egyptians have long been in the habit of doing, and as has often been done in Europe. For example, these hypnotic phenomena are also found to have existed several thousand years ago among the Persian Magi, as well as to the present day among Indian yogas and fakirs, who throw themselves into the hypnotic state by means of fixation of the gaze. So have you ever been in court and had somebody just stare you down, like the judge or the bailiff? Or maybe a cop just stares at you when he stops you and you're not playing along? Okay, so this is can put you in a hypnotic state. Or when you're gazing at something, that you can go into a hypnotic state. The same thing has occurred since the 11th century in many convents of the Greek church. Among the best known are the Hesychasts or Omphilopsychics of Mount Athos, who hypnotize themselves by gazing at the umbilicus. The fact has often been verified in popular opinion, apart from these religious customs, that it was possible to induce sleep by looking fixedly at a certain point, for example, at the tip of the nose. And when someone stares at you, you either have a desire to look away or you just stare at them back, because there's a way to hypnotize people through mimicking. So when they're staring at you and you're staring at them back, they may be trying to use a hypnotic tactic. Hypnotic conditions appear often to occur among uncivilized peoples, as is clearly to be gathered from the information of many travelers, and as Bastian, a chief authority on ethnology, has particularly shown. He, as well as Still, which is a name, Still, has pointed out the near relationship of many phenomena among uncivilized populations to hypnotism. Bastian believes that a more exact study of hypnotism by individual travelers would be of great service to popular psychology. The phenomena which occur spontaneously amongst uncivilized populations could be more carefully examined and brought into close relation to hypnotism. So I'm sorry this was a long section, but I wanted to give you a pretty good understanding. So hypnosis is not really about convincing you in court that you're guilty of a crime, although that is part of it, but that he, the judge, made the correct decision and anyone else reading the case will agree with him. This would include the stories told to the jurors in a court case by the lawyers. All that the lawyers need to do is suggest properly and thoroughly to a jury that you are guilty. So Hugh E. Wingfield says a definition of hypnosis. Various attempts have been made to define hypnosis, the condition of artificially increased suggestibility. Some merely express the theories which different authors hold as the nature of hypnosis. Thus, Myers regards suggestion as a successful appeal to the subliminal self. Sides defines hypnosis as physiologically the inhibition of the inhibitory centers, and so on. Others convey its characteristics as a state in which certain specified phenomena occur. And this kind of description, in the present state of our knowledge, seems to be open to at least objection. Bernheim says hypnotism is the production of a psychical condition in which the faculty of receiving impressions by suggestion is greatly increased. But, as Dr. Lloyd Turkey indicates, this definition does not recognize the extraordinary increase of power to carry out accepted suggestions, which is always found in hypnosis. If I might hazard a definition, I would say that hypnosis is a psychical condition in which suggestions are not only much more easily accepted, but are also realized with an intensity much greater than is possible to the normal state. For however eagerly a man may receive a suggestion in his normal state, it is quite clear that it can be realized only within certain restrictions. Thus, if I suggest a lady in her normal condition that her dress is on fire, though she may at once accept it, the suggestion, and act accordingly. So if she accepts the suggestion and acts accordingly, yet sees that her dress is really not burning at all, the suggested idea would be immediately dissipated. But, as we see later, because this was in a book, if she be in deep hypnosis, so vivid will be the realization that she will believe she actually sees the flames and smoke, and so becomes subject to a hallucination. The attorney or judge does not need to convince you that your dress is on fire. They need to convince the jury and case readers that it was on fire. One such method is circling negative, which in hypnosis is a phrase used by a hypnotherapist when a person has circled himself with negative thoughts and manifests a negative life. They also manifest sicknesses for themselves when they do this. This is done in court through character attacks, making the person look like the type of person who would commit such a crime. Many tactics are used to make the case. Many are simply fictions. So I'm going to get into more of this type of information concerning hypnosis and how it's done, history of various methods used, etc., to help you understand when you're being controlled, how you're being controlled, and even how you allow yourself to be controlled by the way you think of yourself and the world around you. Stay tuned for more information such as this. So more about fictions in law. The writer LaRue, Constitutional Law is Fiction, summarizes my thesis. This is him writing, this is a quote, which is that the proud towers of the law are built not upon level bedrock of fact, but on the perplexed terrain of fiction, and that judicial opinions are filled with stories that purport to be factual, but that instead are fictional, and furthermore, that these fictions could not be eliminated without crippling the legal enterprise. And this is exactly how hypnosis works. They tell stories, they make suggestions to you, they use metaphors and rhetoric and all kinds of things to get you to accept the suggestions. And once you accept them, then you'll start living the life of what you were suggested to. The same way salespeople use tactics to get you to buy things that later on you're like, why did I buy that? So in LaRue, he also states that legal discourse does not obviously resemble the short story or the novel, because they're more... they sound more factual even though they're not. So Fuller in Legal Fictions says, truth is in a state of perpetual oscillation. And when I read this, I really thought that this quote would work really well if it were put in a book on hypnosis. So he says, truth is in a state of perpetual oscillation. Its mobility, its variety is disconcerting. We cannot grasp it without falsifying it. By falsifying reality, I take it Torlin means no more than that we find ourselves compelled to force new situations which bob up out of the eternal flux of reality into the confining framework of an existing intellectual apparatus. Fuller also says this adaptation is so inconspicuous and gradual that it does not impress itself on our minds at all. So when I say things like the Constitution's original purpose was simply to create an agency that controls the military and keeps the military alive and well and going so that if we are ever attacked, we have forces at the ready. People don't believe it because they've been so hypnotized or they've had the fictions grounded down into their minds so deeply that they can't readily accept anything else. So Petrosky, in her book, Fiction and the Languages of Law, says that outsiders of the legal system might consider it obvious that lawyers' language is like make-believe. And LaRue states this in his book. So on one popular view, lawyers are out of touch with ordinary people, playing a game that makes little sense. Lawyers, I'm going to change that. Lawyers, in contrast, might find the suggestion that their language is like make-believe not just wrong but insulting. To them, legal activity clearly has more important consequences in the real world. This book seeks to show how both reactions capture part of the truth as well as to explain why many lawyers might resist seeing their activity this way, end quote. So hypnotherapists would say the same about people who talk negatively about their profession, okay? Because a lot of people don't understand hypnotherapy or hypnosis, and they think it's a joke, and they think it's some kind of trick and some witchery or witchcraft or devil work. And hypnotherapists would probably see that as an insult to their profession. LaRue, in Constitutional Laws Fiction, says that the authors of judicial opinions intend to persuade the reader that the result reached is right. These opinions contain fictions. The use of fictions is essential for persuasions. That's called rhetoric. None of these is obscure or esoteric, but there is no established consensus on how to investigate them or on the terms in which investigation should proceed. People love fiction. People love to believe fiction. It's easy to write in order to persuade people and judicial opinions that the conclusion reached is correct. It is likewise easy to make suggestions to people that they accept a fiction as reality so that they may improve upon their lives. Either way, people love to be entertained. As they say, all the world is a stage. Do no harm. Though all the world may be a stage does no harm. Theater does no harm. Movies and radio do no harm. Hypnosis is to be done in such a way that it does no harm. And I guess TV and radio could be debatable, but it depends on what channel you turn it on. Yet we have a legal system which causes harm to almost all who play within its theater. Its justice cares more about acceptance of its opinions rather than conclusions based on fact, whether popular or not, legislation without meaningful intent to which can be interpreted, and the various interpretations are left to the individual exercising authority, such as the police. And as we know, authority is power and power corrupts. Therefore, those individuals exercising authority are often corrupt and exercise excessive force, use excessive interpretation in order to farm for revenue, policing, and we end up with excessive taxation by private corporations pretending to have government authority to which steals wealth. Those same corporations using police to exercise power to take property from those who refuse a position on their stage, people in prison because they refuse the role of a fiction within a system based on fiction, lawyers and judges who believe they are doing the right thing, Or those who know they're not but do not care. Politicians pretending in the role of stupid, saying they didn't know their policies were causing injuries, and some of them just don't care. People who know the truth and refuse to step out of the fictions, preferring to stay in the role of a coward on the stage where they feel they are safe. Bankers cutting off bank accounts, as if the people who require to pay their bills do not matter. After all, they are fictional characters playing fictional roles on a fictional stage, directed by mostly fictional people with fictional power and fictional authority, imagining themselves as a top character in a movie, yet causing real harm to real people who are sick of playing fictions. Prepping someone for hypnosis is much the same as prepping them to stand in court. Prepping them to accept that the court is real and has real authority and real power, and the system is real and has power and can force people to do things and force them into a system of imprisonment. Hypnosis uses prep work by speaking with a person and telling them what is going to happen, suggesting to them what their role is and what the hypnotist's role is, by letting them know what the outcome will be. When a person walks into court, sees the judge wearing a robe, sees the clerk typing, papers being shuffled, bailiff lurking about, lawyers in suits standing around, an audience watching, the person brought into court sometimes restrained, letting him know he has no power here, that he is restrained, he has no power or authority, he is little and without control. This works on a man's psyche and does wonders in favor of the court. Imagine standing in a place like this, wearing an orange jumpsuit, restrained, and people speaking a language called legalese that you hardly understand. What would you think? How would you feel? Would you think there's not a snowball's chance in hell that you're getting out of here a free person, even if you know you're innocent? That's the point. The point is to do a negative harm, to perform negative circling, and to place you into a negative state of mind so that it's easier for them and less likely you will resist. This is the same thing the IRS does. They send you all these papers when you try to leave them because they can't exist without you. A hypnotist does the same, except into the opposite direction, taking your negative circles and aiding you in making these circles positive, building you up so that you can live a happier, healthier life. So I ask you, why do we allow a legal system to exist that harms people in such a way when the first rule is, and always has been, do no harm? Please like, share, subscribe, and leave a comment. I'll be doing more videos on hypnosis and comparing it to the legal system, sales system. And I'll teach you about archetypes and hypnosis and sales, as well as archetypes in the legal system. Tell your friends to visit my channel, and I'll see you in the next video.